Hello and welcome everyone to our webinar, Is There a Legal Solution to Your Business Challenge? It's presented by Vermont Law and Graduate School and the Vermont Small Business Development Center. It's a partnership through a program that we call Community Navigator Pilot Program, which is a statewide effort to connect businesses with what you need to start and grow. And it is funded in part by a grant from the Small Business Administration. As we get started, I want to cover just a couple of technical logistical pieces. First of all, we are recording this session. We do have live captioning on for those who may want to follow along with the captioning. Please know that it is artificial intelligence that's creating the captioning, and sometimes it may be a little fluky, so please bear with that. Know that we will email this recording and the slides to you later on. We'll also have it posted on our website, which is vtsbdc.org. And look for the menu tab that says Community Navigator Pilot Program. We'll drop that link in our chat, and of course, it'll be in the email that you receive after this session. We also have set this session up as a webinar, so we ask that you please use the Q&A to ask your questions. Our speakers today welcome questions at any time, so please ask away as we move along. And with that, I'm going to hand this off to Professor Killoran and Professor Goodenough.
Hi, everyone. Nice to see you, or not see you, as the case may be. Good afternoon. So we're here to talk about, is there a legal solution to your business challenge? I am Nicole Killoran. I am one of the professors that works in the Vermont Law and Graduate School Entrepreneurship Legal Laboratory. I'm directing the program, and with me as well is Oliver Goodenough. He's also a professor of law, and he contributes to the program. So before we get going, I want to set out a couple of goals for everybody. We're hoping that you come away from this with three things. We want you to understand some common business issues that have a legal solution. We want you to have some useful tips for how to hire and work with a lawyer and how to exercise some control in a relationship that otherwise might feel imbalanced. And I want to give you some free tools for your business. So that's the goals for today. So let's start with, why hire a lawyer? This might be a question that some businesses have asked themselves. Let me give you a high-level view of how a lawyer can be a helpful member of your team. Many people think of lawsuits when they think of lawyers. They think about fixing people's problems in court. We pick up the pieces when something goes wrong, right? But that's really a small part of what lawyers do. Lawyers like helping people prevent problems, not just fix them. Believe it or not, a lawyer can help you with a lot of different legal needs over the life of your business. And they can also be there to catch you if something goes wrong, but we do like to help you prevent problems. So why are they helpful? They have a duty to give you their best possible competent advice. It's written into the rules of professional conduct for our profession. They have to either be knowledgeable or become knowledgeable about the issue that they're helping you with. There is no question of loyalty. They're going to be on your side. The ethical rules require them to be. They have to be loyal now and in the future, even when the relationship ends. They can also serve a lot of different roles. They can be your legal expert on legal questions, right? That makes sense. They can also educate you, not only on legal issues, but they can give you some ideas of best practices. They can give you background on your legal questions. They can connect you with resources that you can access. They are obligated to provide you with competent advice. I've mentioned that, so they're a good advisor. And if something does go wrong, they can step up and they can represent your interests if you need them to. And that includes both litigation and lawsuits, and it can also include negotiations. So they can help you spot legal needs early on, and this is important because being able to prevent problems is usually cheaper than having to fix problems and pay to fix them in the future. And they can be a really great resource once you form a relationship. If you're not sure if you have a legal issue, but you want to find out, it's nice to have someone who's familiar with your business who can give you a half-hour consult on that. So what we're here to show everybody today is to give you a broad overview of some major legal issues that most businesses encounter. Before I get there, I wanted to just talk about this idea of legal issue spotting. Lawyers are trained to find legal issues. This is what we do when we go to law school. We're trained to look at someone's situation, to figure out whether there's a legal issue, and then figure out if there's a solution or what the outcome could be. That's basically the practice of law, spotting issues and figuring out solutions. but non-lawyers can do it too. It's not that hard once you have the information that you need. How do you do it without going to law school? Well, what it comes down to is lived experience. If you have lived experience, it gives you a sense of danger. If you have been a business owner, you've likely had lived experience. There are some younger entrepreneurs, but most folks have a little bit of life experience. Do you know what it's like to feel like something's risky? Have you ever felt your gut instinct, your gut feeling, something doesn't feel right, seems dangerous, you don't like it, it doesn't seem fair? When you're an entrepreneur, you develop a sense of optimism. You dream, you reach, you grow, you innovate, but you also develop a sense of things that don't seem right or seem risky for your business. What I encourage you to do is to tap into that sense, because usually when something doesn't feel right or feels risky for your business, you've already identified a problem that has a legal solution to it. So, what do legal issues look like without legal training? This is where we're going to give you a bunch of information about basic legal concepts. I want to emphasize here, an ounce of prevention is really worth a pound of cure. The Benjamin Franklin quote is very true here. We're going to walk you through some common examples of what it might look like when something doesn't feel right or feels risky when you're running a business. We'll cover 5 areas of law that are the most common questions we have from business owners who come to us to learn about legal issues. Business entity formation, employees and human resources, HR, managing risks, intellectual property, and contracts. So I'm going to hand it over to Professor Goodenough to talk about business entities first.
Thanks so much, Nicole. If I could have the next slide. One of the things that we're structuring today is to kind of say, how do these things present to you as a business person, and why is it that there's some legal issues that trail along with that? So what does it look like when you're thinking about a business entity? Well, the obvious beginning point is you have a great business idea and you're ready to start up. Well, how do you go structure that? Because these business entity questions provide the legal framework with reliable answers on all of the questions we're going to see here. Could also present you've been in business for a while, but you're not sure whether to make it official. There's a lot of businesses, small businesses in particular, start out quite informally. It's just somebody doing something. And as it grows and matures, it may be time to think about putting an official entity in place. Another common point is you need some money. If some businesses are able to self-finance, others need external finance, either investors or perhaps bank loans or other things like that. And in those contexts, you really want to have some kind of formalized structure. Your investor may require it, but even if they don't, it's a really good idea to make sure that both the investor and you have an official structure that allows you to take that money on. Somebody wants to join you as a partner or an investor, not just an investor, but also a business partner. What's the deal? How's it going to go forward? And as you do this, you may be asking yourself, how much risk should I take? Is it okay for me to have just all be on me, or do I want an entity in place that may have some ability to limit my personal liability from the debts of the business if something goes wrong? What do I want to look like now and in the future? Because this is not just a question about where you are today, but open to having it grow. How do I want to pass it on to my children, my nieces and nephews, my spouse, whoever it is you're going to be dealing with in this context? How do I separate myself from my business? Again, this is that risk piece, protecting your own assets. What if me and my partners don't get along or can't agree? This is the thing that people often don't want to spend much time on, which is what happens if there's a dispute? How do we get out of this problem? So these are the ways that typically, some of the ways that these questions will present to you, and are the kinds of things that lawyers and the structures they can help you to create or navigate can be useful. This chart has been developed by one of our students to help formalize some of this. And on the left-hand column, you see the kind of menu of business forms that is available to folks in the United States. Sole proprietorship, do you own it just yourself? Is it a partnership of some kind? Is it an LLC, a limited liability company? That's a very popular format for a small and medium-sized business. Is it a corporation, which is more popular typically for more established and highly financed businesses? Could it be a co-op? Here in Vermont in particular, we have a lot of co-ops, and that's a very useful form if there's going to be a wide participation among folks like customers or suppliers. Do we want to be a benefit corporation? That's a particular kind of corporation that's available for social benefit purposes, or even nonprofits, because many enterprises that get going might actually fit a nonprofit model. And then across the top of this chart, you see the kinds of questions that we typically look at as who's the owner? How does the ownership work? Is there a liability shield? And in a personal sole proprietorships or traditional partnerships, there's not typically a liability shield. So that's one of the reasons people may reach something like an LLC. How's the funding coming from? Is it coming from self-finance? Is it coming from investors? Is it coming from outside loans? And then there's a big one. What are taxes like? Because some of these entities have what's called pass-through taxation, where there's a direct link of your tax return and the businesses. But some also, like corporations, have entity level taxes where the corporations pays tax as well as the individual under many circumstances. So these are the kinds of issues that a lawyer will help you navigate. They'll basically help you through this kind of list. Next slide, please. And often they'll help you put it into some kind of formalized document. If you're an LLC, that's typically called an operating agreement. If it's just partners, partnership agreement. And in those agreements, the lawyer will help you spell out what are your duties and responsibilities to each other if you've got other people you're in business with. Who's going to make contributions? What money is going to come in from where? And what are the ownership percentages? And how's it all going to divide up? Who's going to vote? How's it going to get managed? Dispute resolution. As I mentioned, we don't like to think about the fact that we may have an argument down the road, but many businesses don't end up always happily. And if you planned ahead for that and have a dispute resolution clause, then that you can deal with that. And that can sometimes lead to a dissolution of the business. If we do that in a planned, orderly way, it's a whole lot easier for everybody than if we're just making it up when that happens. So again, these are the kind of issues that a lawyer can help you focus in on and then provide you with the operating agreement or other documentation that will anticipate your problems and help provide solutions. I think the next topic, there you go, Nicole, I'll hand back to you.
There we go. Employees and HR, human resources. So thank you, Professor Goodenough. So this question comes up a lot. And this is, we consult with small businesses all the time, and HR is a big question. So what does it look like? What does it feel like if you're a business owner? Say you've been a sole proprietor and you want to hire your first employee. What the heck do you do? What do you need to be aware of when you're paying them, when you're hiring them? Say you want to add more employees to your team. Say you're thinking about even setting up an employee handbook. If you have a big enough team and you want to set out some expectations, what do you have to think about? What should you put in the handbook and what should you not put in there? And there's always, of course, the danger of an employee thinking that they're not being treated unfairly. That's one that comes up quite frequently. How do you prevent discrimination claims? And there's also one that I haven't put on this, which is how do you prevent unemployment claims? So unemployment insurance can go up if an employee files a claim, and it may come out of the business's pocket. So these are sort of what the issues look like usually in HR. Let's go over some basics. Vermont is an at-will state. That just means that an employer-employee relationship is voluntary. That's the default. The employee can leave or they can be fired at any time for any reason, unless it's an illegal reason, like discrimination. One of the big things that come up when dealing with legal issues as an employer are issues with hiring and firing, job postings and descriptions. There's a couple things to know here. Vermont is a ban the box state. So if an employer is looking to hire and they have an application, they cannot ask for criminal history information on the application. They can run a background check, but they have to give the potential employee, a chance to explain if something comes up. When interviewing an employer, so this is a pitfall for employers sometimes, don't take notes on an application or resume, because that can actually factor into a discrimination claim. It's important to think about job requirements. The big thing to remember about job requirements when making a job posting is that categories can be dangerous. So for example, the important thing here is to focus on qualifications and requirements. So must be able to lift 50 pounds is usually pretty safe. Looking for a strapping young male candidate is usually not safe. or must be authorized to work in the US is usually pretty safe, but must be a US citizen or have a valid US passport could have a discrimination claim on your hands. Job descriptions can protect from lawsuits. They can be useful, especially if you have multiple positions and multiple employees. They explain the requirements, they explain the duties and the responsibilities and the physical demands. That's an important piece of documentation for an employer. And all of those things, job descriptions, job postings, those can create legal issues that an employer needs to be aware of and that you could use some legal help with. Independent contractors and employees, there is a difference between an employee who gets paid with salary or hourly and who can get unemployment, and an independent contractor who does not. The difference falls down to how much control the employer has and the nature of the work. Again, this is a legal issue that comes up in different businesses that creates that could create a need for a lawyer to consult with. Employee classifications and payroll, some of those can actually be dealt with by talking to an accountant. But the important thing to know here, the legal issues, is if an employee is not independent, and in other words, if they are a salaried or an hourly employee, they have to get paid at least minimum wage, and they might get overtime. They might have a wage and hour claim if they don't. And it depends on whether they're in a managerial position and or salaried, which is an exempt position, or hourly, which is non-exempt. The other one to be aware of, unemployment. Unemployment can be a little tricky. The important thing to know is that employees who are let go for no fault of their own may be able to submit an unemployment insurance, or may be able to submit an unemployment claim, which can raise the cost of an employer's unemployment insurance. So as I'm going to talk about with discrimination, the key to preventing unemployment claims is really documentation. It's being able to show a document that says this person was disciplined, this person did not perform the job as expected, and that this is the reason why they were let go. So unemployment can create some legal issues. And there again, too, it can be really helpful to have a lawyer on hand if you have a problem employee. You can just pick up the phone and say, can I have a half hour to talk about this person? I don't know if I have the right documentation, if I'm doing this right. I really don't want to have to pay out for this. And then finally, handbooks and implied contracts. These can be tricky. Say you're at the point where you really want to create some expectations and you want to describe benefits in an employee handbook. These can have some legal pitfalls. We'll talk about contracts more later, but what I want to talk about now is something called an implied contract. That's something that's not very clear, but that someone can argue, in fact, is something that someone agreed to. So a couple of examples. Employee handbooks can be a great way to set out expectations, policies, benefits. They can also create an implied contract. Remember, the default for Vermont is at-will employment. So a couple of examples. Job security. We won't fire you if you do a good job. And an employee handbook could turn into, you can't fire me as long as I'm doing a good job. So it can change it from an at-will employment to a more permanent employment. Or probationary period. For the first 3 months, you are a probationary employee, could turn into, once you're done with your first 3 months, you're a permanent employee. So again, some of these things can create legal issues. A lawyer might be able to help you put together an acknowledgement form that an employee can sign that says that whatever the employee handbook says, you're still an at-will employee. I'm going to talk now about discrimination. This is another big legal issue that comes up and that can cause problems for employers that they'll need legal help for. Nicole, so there's a couple.
Nicole, there's a question.
Oh, okay.
Before you go on, there's a question saying some federal and state monies require an operating agreement, but many of my businesses are single members, LLCs, and they don't have an operating agreement. What does the minimum agreement look like in this situation?
Take it away, Professor Goodenough.
Just to go back on that, actually, single member LLCs can have an operating agreement. It's just a declaration of the way the company is going to run with the single member. There are examples of that. I've in fact drafted some. They are essentially statements of how it will run, and sometimes lays out things like the authority of officers and that kind of thing. It doesn't handle so much the concerns about disputes and things like that, because with a single member, it's not going to do that. But just because there's a single member doesn't mean there can't be an operating agreement. Is that an adequate response?
The response is that they don't have them.
The problem is that they don't have them. I think that's what she's saying.
Yeah, well, then they should, if they need them for some kind of form or whatever, it is not, what I'm saying is that it's not a contradictory term to say that a single member LLC can't have an operating agreement. It can have an operating agreement. And that operating agreement basically says, here's how this LLC is going to run, even though it's just me owning it.
I think the question is that what is the minimum that it needs to look like if they have nothing?
Typically an operating agreement, again, I'm not going to get into the specifics, so we can provide some resources perhaps. An operating agreement should, even for a single member, probably be 4 or 5 pages long, talk about whose money, what's its purpose, how is it getting established, what money is coming in. Even if it's just coming in from the sole owner, it should say that. How decisions are made. If it's a sole owner, it'll say all the decisions will be made by the sole owner. It'll talk about officers, because even if it's a sole member, there might be a couple of other people who would operate on its behalf. A little bit about taxes and dissolution. 4 or 5 pages is probably what's going to be a minimum length for that kind of a statement.
All right.
Is that adequate? And if there's a follow-up question, perhaps we'll take it in the Q&A time.
Sure. Let's talk about discrimination. Fun stuff. So there's things to be aware of for discrimination. And this is, again, what this looks like is an employee believes that they're not being treated fairly. So what are the different things to be aware of in terms of the legal issues? There's a number of different protected categories that you can see here: race, ethnicity, religion, sex, national origin, age, which is over 40, disability, and even genetic information. And discrimination claims can come up at all different stages of an employment relationship: hiring, firing, promotion, and demotion. I'll go into details later about how to avoid some of these discrimination claims, but the big things to be aware of: the Americans with Disability Act applies to employers who have 15 plus employees, and it requires that if an employee has a disability, that as long as it doesn't create a financial burden, too much of a financial burden on the employer, the employee should have reasonable accommodation. But important to note here that disability is one category that's protected under discrimination law. So even if a business has less than 15 employees, it is important to still treat employees fairly to avoid discrimination claims, and also to just treat them fairly. So discrimination at the basic definition is that it's treating one person different than another person in a similar position without a good reason for it. And it can cause a lot of problems for employers. So here again, it can help to have a lawyer that can be involved, that knows the business. Even if there's a hint that there's going to be an employee who thinks they're not being treated fairly, it can help for an employment law lawyer, or even somebody who has experience working with employers, to be able to take a look at your business and say, this is how you can avoid it. 2 ways to avoid discrimination claims: consistency and documentation. Consistency, what does that look like? If you're doing a background check, run it on everyone. Do you have a job description for the position? Have a job description for everyone. Do you have a progressive discipline policy? You better make sure everyone goes through it and that you follow the same process. If you're training your employees to help them do their job better, you train everyone doing that job. You don't just train someone who's being disciplined or who you think needs help. And then documentation. This is really what's important. And I mentioned it under unemployment. This is key to protecting an employer if a problem comes up in a lot of different areas. So documenting the reasons someone is being disciplined, documenting performance issues, documenting training. If there's an employee handbook being handed out, documenting that the employee is acknowledging that this is an at-will employment relationship. Documents and notes can be very helpful for an employer to be able to head off legal issues in the future. And again, it can help to have a lawyer on hand to just call up and say, can I have a half an hour to talk to you about this problem employee I have? I'm not sure if I'm approaching this the right way. So that's employment law and HR law at a very high level. I'm going to move on to risk management, unless there's any, I don't see anything in the Q&A right now, but I'll pause if something comes up here. We're going to go on to risk management. So this is another area that's very common, a very common question for businesses. What does it look like? It comes down to whether someone or something could get hurt. That's really what it looks like. And this could involve, someone getting injured on site or in the business's space, or a business that has potentially risky situations. Someone who could be hurt someone could be hurt by a product, or there could be a product that's consumable, which comes with it, which brings with a small amount of risk. So that's sort of what it looks like in practicality. And employer and business owners really think a lot about risk because they don't want it to affect their business. So it makes a lot of sense. Some basics on risk management. Torts is the area of law that lawyers, this is not a pastry, they call it, this is the body of law that lawyers have that basically deals with people getting hurt. The first thing to know about is there's a standard that is not super, it's not super firm. It's called the reasonable person standard. The reasonable person is your totally average person who takes reasonable care to prevent injury to another person. This is something that doesn't exist. There is no reasonable person, but it is something that the law holds up to say, this is what everyone should be doing. They should be taking reasonable care to prevent injury. There's a couple of different liability kinds that apply to businesses usually. There's premises liability, which falls under two categories. Someone gets hurt walking into the business's space. Think about slip and fall, ice falling. That's often part of insurance policies that talk about someone getting hurt in the building. But then the part that businesses think about more is someone gets hurt in an activity in the business. So think about gyms, training facilities, rock climbing gyms, recreational businesses, or even someone who has a fleet of vehicles or who has an employee who's driving around. Often, if someone is going to get hurt in an activity in the business, a waiver is what comes into play. And there's a couple of different kinds that I won't really go into details about, but the waivers, the important things to know is that a lawyer can be very helpful to write a waiver. They can write it specific enough that it's going to protect a business, but also make sure that they can review some of the policies and safety measures that a business has in place to try to prevent injury. There are some exceptions to waivers, and it's usually if they're too broad, or if they if the business doesn't anticipate some of the reasonable needs of their customers. An example is not having a defibrillator on hand in a gym that sells memberships to elderly customers, or not having a lifeguard on hand at a swimming pool. Those are examples of things that a business may not be able to protect itself against. Product liability comes up a lot with business owners. This is basically protecting people from getting hurt by your product. There's three different kinds. There's a design defect where the product isn't designed safely. So think about a baby toy with small parts, or a slide with short sides rather. There's manufacturing defects where the product might be designed safely, but in the manufacturing process, something makes it dangerous. So think about a drink that was manufactured to have an exploding bottle cap, or even the canned food that has metal shards in it. That's a manufacturing defect. What we run into a lot with businesses is marketing defects. And this is usually handled by warnings and instructions, another area where a lawyer can really help you take a look at your labels, your warnings, and your instructions. And I'm going to finish up the product liability thing, and it looks like we've got a question in here too. Marketing defects are pretty common. The important thing to know is that businesses have to think ahead to how potential customers could be hurt, but businesses don't have to anticipate everything that could go wrong. Again, there's the reasonable person standard. The business has to think about something that an average person could anticipate might hurt someone. So a child's toy with small parts that has a label that says not appropriate for children under age 3. There can be other requirements too. So consumables and labeling, because there's a potential for injury, there are specific rules for selling something that will be consumed. Many of them are administered at the federal level. There will probably be regulations from the state and the federal government, depending on the product. It's important to know that labeling is different for different products. If it's consumable, it's going to have one set of rules. If it's a children's toy, it's going to have another set of rules. Alcoholic beverages have different rules than other drinks. And even things like herbal supplements have different rules than herbal teas, for example. So different rules to pay attention to. And here again, it can create a legal issue where if the business wants to manage its risk, it would be really helpful to consult with a lawyer to be able to make sure that things are labeled appropriately. And then finally, 2 ways a business can protect itself from risk, and that's insurance. Insurance can be a really helpful way to, well, insurance is necessary, right? But insurance can also provide some information to a business owner about what risks it needs to anticipate. It can be a really great resource. You can get a free quote from an insurance company usually. there can be different insurance policies that are specific to a kind of business that will protect against common risks that are inherent with that business. And there often are best practices that an insurance company can suggest to avoid someone getting hurt. And then another thing to think about is, as Professor Goodenough mentioned, limited liability entities. Is it time to put the business in a protective wrapper and have some sort of a barrier between the business owner and the business activities? So that's risk management in a nutshell. And then we have a question here. My daughter has a sole proprietorship and provides activities for parties in clients' homes, for example, children's birthday parties. What insurance does she need? Some companies have said they won't insure her because she's a sole proprietorship. Or does she just need to get clients to sign a waiver? So there, it's difficult to answer because we can't provide specific legal advice. But my high level response would be that sometimes going from a sole proprietor to an LLC, for example, can give a business a few more options in terms of insurance, in terms of financing. And you might often see conditions like this if a business needs to become more official before it can really get protection for what it does. That's pretty common. And then again, a waiver can be very useful if the activity is potentially dangerous. So is there danger to the people who are going to be engaging in the activity? Well, then a waiver that's specific enough but not too broad might be helpful to try to protect against the potential dangers there. Professor Goodenough?
Yeah, I might add that in addition to lawyers as a good resource in this context, insurance agents, a really good experienced insurance agent and knowledgeable in the business that you're looking at can be quite an asset as well, because they will have seen a number of different possibilities here. They will help steer you and say, yeah, we can't insure you here. Instead of just saying no, they'll say, hey, we couldn't insure you in this approach, but maybe this approach would work. So again, in addition to lawyers, accountants, insurance agents, sometimes bankers, other folks like this can also be sources of wisdom, if not necessarily official legal knowledge on some of these questions.
Okay. I think it's your turn now, Professor Goodenough.
Okay,
Intellectual property.
Next slide.
Yeah, I'm on it.
Okay. Except I'm not seeing it yet.
Oh, I'm sorry.
There we go. Intellectual property. How does it present? Actually, we may go back one, I think, for that.
Oops.
Yes, how does it present?
Sorry, it's advancing backwards. Hold on just one second.
Well, I can keep talking. There are really two ways that these questions present themselves to you. First of all, the question is, are you making, designing, or creating things or information? Because that's kind of what the intellectual property laws protect. And the first sort of branch of intellectual property question is someone using your material? Are you trying to protect the material that you have created and prevent other people from profiting from it, or profit yourself from licensing or use of it? That is, I think of as kind of intellectual property as offense, where you're using it to protect your work. But there's also, for most creators, the question of intellectual property on defense, which is, are you using someone else's material? Is that okay or not? What permissions will you need? There's a branch of law sometimes called clearance, where basically we sit down and say, okay, what permissions are you going to need from other people to use this material? Sometimes you can use material without permission. It's called fair use, or other reasons why you can use other people's material, but it's no guarantee. And again, this is a place where some professional help and guidance can be useful. Next slide, please. There are 4 major categories of intellectual property that we come across typically when talking with people. The first is copyright, and copyright applies to works of authorship, fixed and a tangible medium of expression. So books, music, movies, TV, that kind of thing, videos. That's all the kind of thing that copyright would protect. And copyright attaches in the US immediately on creation to work by an author, and gives protection even without filing. Filing is useful. There is a series of procedures to file, but they add protection. They aren't a requirement for any protection at all. You should also be aware that there's something called works for hire, where people who create works either as employees or some kinds of commission works, the company can then be the owner of the work rather than the individual author. But one way or another, under copyright, there's a set of protections that include coverage for making copies, for distributing copies, for performance, for all kinds of things. Even things like having a sound system in a store or restaurant can implicate copyright if the store owner is playing copyrighted music or providing video on top of that. Having a TV on behind the bar can implicate intellectual property, because that would be a performance in a commercial context that would be something that would be potentially a problem. There are ways that are allowed to do this. There is this fair use doctrine for small uses and things like that, but they also tend to be relatively specific and fact intensive, and the kind of thing that getting some legal help might be useful on. Some self-education can sometimes take care of this, but again, these are areas where legal help may be helpful. Trademark is a branch that identifies the goods, the origins of goods and services. Who is it who is providing this? So if you buy a soda that's labeled Coca-Cola, you're pretty well guaranteed that that's coming from a company that is either the Coca-Cola company itself or a company that's allied with the Coca-Cola company and is producing under license of some kind. A trademark or trade name could be very helpful in even much smaller businesses, where if you've got a product of creating quilts, but it's a special kind of quilt, qualified quilts, maybe a trade name that people want to use for their quilting, or maybe it's Quaker style, Quaker quilts, anyway, Quaker qualified quilts, whatever it is. When it starts to be an identifying tag for the products or services, now it's what's called a trade name. And again, there's offense and defense on this, because on the one hand, a business wants to protect its name and make sure that others aren't using it. But also, they need to make sure they're not using a name that somebody else already used. If it turns out that somebody up in Barrie got going on qualified Quaker quilts first, you don't want to be tripping over and having them come back and say, hey, you can't use that. So again, here's an instance where there's both basic protection for just comes from use, but there's also the possibilities of registering a mark, which can get added protection. Registration is tricky, can be done by individuals, but it's again one of those areas where getting some legal help may make a big difference. Also, before a business gets started, it really should check out the names it's planning to use to make sure that they're not the property of some other company, and that also can be helped with a lawyer, although self-help can happen as well. Patent is an area of law that involves discoveries, inventions, that kind of thing, medicines, machines, processes, things that are new and haven't been done before, and are new ways of creating products or processes. So that you should be aware is something that if something is patentable, if it's not patented within a year of first being used by its inventor or put out in the general public by its inventor, the potentiality of protection may well be lost. So if a company thinks it's got some patentable stuff, it ought to talk to a lawyer early on in the process rather than later in the process and discover that they've lost rights they might have had. So if a company is involved in a technological or other area where they're going to have inventions, talking to a lawyer early in the process to set up some guidance is a very useful thing to think about doing. Trade secret is sort of like an unofficial patent in a sense, in that what happens is that even if it's information or an invention isn't patentable, if it's kept secret, the law will help keep things secret. The key to a trade secret is that it's a useful secret that is not generally known to the world, and that the company has taken reasonable steps to protect. So it's got to be a useful secret, and there has to be a set of reasonable steps taken to make sure that the plans are locked away, passwords are necessary for all of the computers. If a company is concerned about trade secrets, again, a lawyer can help set up those criteria for that. And when all of these are put together, there's also licensing. And licensing is the process where the company gives permission to others to use its intellectual property, like publishing or a patent license or something like that. But it's also the process of getting rights in from others that you may need. Remember, we talked about offense and defense. You can license to others, but you may have to license from others. If you're going to use a particular copyrighted song or something like that, you may well need a license. And license agreements are just complicated enough that a lawyer can often be very helpful in terms of that. We'll talk about that in contracts in just a minute. Okay, so that's the basic categories of intellectual property and the questions of how to use it for offense and defense.
There is a question in the Q&A.
Yep.
Deborah Boudreau, who's got lots of good questions today. Which areas of business law, like IP, require a lawyer who has specific training? I'm assuming HR is probably another one. What are the other major areas that lawyers in business specialize in? And what's an easy way? What's an easy way for a small business owner to understand when they need specific focus and when a generalist is appropriate?
What a great question. One of the a way is sometimes just ask the lawyer, do you feel comfortable handling this and handling it quickly without having to come to a lot of education? And if the lawyer says no, well, now sometimes lawyers can be a little overconfident in their own abilities, and that's important to know as well. Some of these more technical areas can benefit from a specialist. The more technical sides of trademarking, for instance, or patenting. Patenting is almost always requires a specialist. That can be useful. Many business lawyers will know enough around business entity formation and tax, and to some degree around some of those HR issues. So, a kind of a business law generalist will often have enough background to be able to deal with the things that come up with a small business, which are often not requiring terrible depth of knowledge. Again, I'm not sure you want to go to your family lawyer or a criminal lawyer and say, "Hey, help me set up a company." That's not a great idea. But practitioners who hold themselves out as being business lawyers will often have enough breadth to cover this, and hopefully be honest enough when the time comes to say, we really need to pull in some additional help.
So that's a great answer. Thank you, Professor Goodenough. And when it comes to finding someone, I'm going to get into, after Professor Goodenough covers contracts, so we'll talk a little bit more there about how to find a lawyer and how to try to target somebody that's going to be good for a business's budget as well as for their needs. So do you want to go ahead and take it away for contracts, Professor Goodenough?
Okay, contracts. How does this present? Well, why do you want things in writing? So they're clear. One of the things that the contract really does two things. First of all, a good contract provides a blueprint for the activity. So suppose you're you're setting up that event company that was mentioned earlier, the birthday party and other events. A good contract will have a good description of what the organizer is going to deliver. Is it going to be lunch? Is it going to be dinner? How many people are we planning? What's the menu? Are we going to have a clown or a pony? I mean, all of the things that are key blueprint to the activity that's going to go forward. A good contract spells that out. Sometimes that's the description of work that gets attached at the end. Whatever it is, the blueprint aspect actually is the starting point of importance. And the second thing a contract typically does is it contains some allocation of risks and liabilities. What happens if it goes wrong? What happens if it rains on that day and the party's called off? Is the money still owed? Is it not still owed? What happens if the food's bad and everybody gets sick? Is there a waiver? We can do some of that liability allocation. So a good contract really does those two things, of providing a blueprint and some protection. The individual business person is often pretty good at the blueprint aspect if they think about it and take the time to sketch it out and say, here's what we're going to do, because that's what the business person does. But this protection aspect is almost always benefited with a lawyer. They're trained to think about some of these things. There's a lot of technical aspects to this that the individual business owner often doesn't think about. And again, a lawyer can be sometimes quite additive particularly on those questions. Sometimes they can help you think out the blueprint too, but lawyers are systematic, if nothing else. And so that systematic thinking can help on all aspects of a good contract. Next one. So what is the contract? Contract is classically a statement of some kind, often in writing, typically in writing, although increasingly actually in code of some kind, but typically in writing, setting out the blueprint, the liability structure, all of those issues that we've talked about, which is the understanding of the parties, and then often agreed to in a formal way through a signature is typical. Although again, that's often moving online. A DocuSign signatures are legal in all 50 states, and so again, the physical signature piece doesn't have to be there necessarily. The contract can refer to other documents. Sometimes it says we don't refer to other documents. If it is going to refer to other documents, then make sure that reference is explicit. So what are some of the pitfalls? You don't have a contract. Well, you probably do actually. If you've sold something to somebody or you're doing work for somebody or something along that line, there's probably at least an implied contract there, and just the terms haven't been written down, and now we've just got to have a much greater argument. One of the nice things about having them written down clearly in advance, that blueprint, is then we got a lot less argument to go forward about what the understanding of the parties were. But once actually a company's taken some money and shipped the goods or started doing the painting or whatever it is, you got a contract of some kind in that context. Is it standard contracts? Standard forms are interesting. They can be useful for a business owner because they can help a business owner with some relative cheapness get going on something. Even with a standard form, it's often useful to have a lawyer look at it because your actual business may not fit that actual standard. As they said in the advertisements for the garages and spare parts on automobiles, you can pay me now, you can pay me later. Getting a little prevention early on can be helpful in that. Manufacturing and distribution, that's a kind of contracting which is often a little more involved because they're the allocation of risks, the allocation of liabilities, that kind of thing can be rather complicated and worth having an attorney look at. Same with distribution and licenses of intellectual property. Again, that can be complex enough. Sometimes a lawyer can help you set up a set of forms that are appropriate to you and then be on call only if there's something complicated as you go forward. Leases are another thing that can be worth having a lawyer look at. There's enough complication and depth in the clauses of leases, which are a specific kind of contract. Business leases don't have the same protections that individual personal leases have in Vermont. Business leases are typically much less protected by consumer protection than individual leases. So again, what's in the contract is in the lease is likely to be what's going to be enforced, and so it's worth having that looked at. So there's not a problem. Okay, if we move on. Finding a lawyer. That question. Professor Killoran, you'll take it away.
Yes, I'll take this away. So finding and working with a lawyer, right? There's two important parts there. So how do you find a lawyer? It's a couple of different ways. The main ways that I want to suggest here are there's a great referral service for the Vermont Bar Association, the Vermont Lawyer Referral Service. And that can connect businesses with an attorney who's agreed to provide a half-hour consultation for $25. There's also our program, Vermont Law and Graduate School Entrepreneurship Legal Laboratory, VSEL. We provide referrals to attorneys who want to work with businesses. We also provide an educational consult, myself and Professor Goodenough and our colleague, Professor Jeanette Ikes. We also, for qualifying businesses, pay for the first 5 to 10 hours of services for that referral. So that can be a way to find an attorney. Word of mouth is very common. This is where you talk to a friend, talk to a colleague, you talk to someone else in a business like yours. Who do they work with? You can also lean sometimes on industry associations. They can be a great resource for attorneys who are helping businesses that are in that industry. The industry associations can also be a great resource for documents that other businesses like you are using. And then Google. There's a lot of websites out there and there's a lot of lawyers. You'd be surprised what you can find. You do have to take Google with Google results with a grain of salt, of course, but there's usually a website that advertises the lawyer's specific area of practice. And as Professor Goodenough noted, you don't have to be a business lawyer. You can be someone with a more general practice who can also help with some of your needs. When it comes to interviewing a lawyer, it can be, I highly recommend that anyone, anytime they encounter a lawyer, ask for a free consult. You don't know if you don't ask.
And that going in first conversation, many lawyers will say, hey, that's on me, because we're just exploring. Some lawyers will send you a bill for it, and you want to be absolutely crystal clear that's not going to happen. That really is, at least in my opinion, not an appropriate way for an attorney to go. That first consultation about should I hire you, not, is that ought to be for free.
Yeah. There's many lawyers will do it automatically, like Professor Goodenough said, and yeah, very good to get that confirmed in writing if you can. Conflict check. This is something that lawyers have to do, because remember, they have a duty to be loyal to you. So they may have to run a conflict check to confirm that they can be completely loyal to you, because they have not represented anyone who's on the other side of a dispute from you, or who might have conflicting interests. So expect a conflict check. And then finally, confidential. Lawyers have a duty to keep information that you share with them confidential. I say this because it's important when you're interviewing a lawyer to not hold back. Give them the information that they need to give you good advice. It can include embarrassing details. You'd be surprised what lawyers learn, that they have to keep it all confidential. Share openly so they can give you an honest assessment of what you need and where you might be at risk. And then another suggestion, write down your questions. If you want, you can get an education first. I'm going to provide some free resources to help folks educate themselves, and then also include key players in the interview. If you're going to talk to a lawyer about an HR issue, for example, and you have a manager who might have some knowledge, you can include them. Or if you have an accountant who might have some questions, if you're thinking about switching entities, make sure you include the important people there.
The one piece I would caution there is just check that sometimes with the lawyer first, in case there's a privilege concern. That the wrong people involved can sometimes make it an unprivileged conversation. So what Professor Killoran said is absolutely correct, but probably want to just check that with the lawyer first.
Yeah. When it comes to the cost, there's a couple of different ways. Buy the job is a flat fee. This is a small amount of work that is done for a flat fee for a set amount. There's by the hour, which is usually more open-ended for an hourly fee. There is contingent, which is more common with litigation. The lawyer doesn't get paid unless you win your case. You can limit what lawyers do and you can decide how you're going to pay them if they'll agree to it. The retainer is simply money up front. It's sort of a deposit, but a lawyer pays themselves out of a retainer if they're billing you hourly. There's a difference between pro bono and low bono. Pro bono is free service. Low bono is service at a lower rate. For example, VSEL provides $75 an hour for the first 5 to 10 hours to an attorney that we can refer you to. It's always important to ask. Here again, you don't know if some attorneys can help if you can't pay. Some attorneys don't have the bandwidth to do that, but you don't ask if you don't know if you don't ask. You may not realize you can negotiate with an attorney. You can negotiate fees, you can negotiate bills, you can negotiate the scope of work that they're going to do for you. You can set a budget and tell them to stop working when they hit that limit. You can say, don't work anywhere past this, if there's $1,000 left of the retainer, stop working. You can also barter. If you're a business owner and you have a useful good or service, you can trade cheese for lawyer fees. You can trade services for lawyer fees. It's very common in Vermont, and one of the joys of practicing here, frankly. And then finally, scope and expectations. You do have some power in the relationship. You can decide what they're going to do for you, and you can set expectations for when to communicate, when to get an update, what's going to happen at what point. You can also fire your lawyer. And then billing. I won't go into too many details with this, but this is usually how lawyers communicate to their clients what work they've done, especially if they're taking money out of a retainer. So that's hiring and working with a lawyer at a high level.
If I could briefly, you mentioned retainer. Sometimes people have confusion over retainer. Retainer is not a fixed fee. So if you go to a lawyer and they say, I'll need a $5,000 retainer, that does not mean that that's an estimate or the cost or whatever. That's just they require a deposit, an advance payment of at least $5,000. So they know that they're going to get paid at least $5,000 if they send bills. That is not a cap of any kind, and you should never think about that. A cap can be negotiated, but it will be called that, cap fee kind of approach. And if you're anticipating that that's what you want, make sure that that's what you're negotiating, and something called a retainer won't give that to you.
Yes, thank you. All right. The only thing I have left is here's some free programs, some free information, some DIY resources. I've mentioned VSEL. You can see the website here, and I'm going to hand this out I put this into a document so I can hand it out to attendees after this webinar. There is a great free information resource at the Vermont Law and Graduate School Library, the Center for the Community Legal Information Center, CLIC. This can be either access legal information, include legal databases, or it can be delivering books with legal information to your local library. If you're a veteran, there's a Veterans Legal Assistance Project through Vermont Law School. There's also the Small Business Development Center. They don't provide legal advice directly, but they can refer you if you're working with one of their advisors and the advisor thinks you might benefit from an educational consult, back to us. There are other webinars that we have done through this program, through the Community Navigator Pilot Program, that you can see the website there. And again, this is going to be on a handout I'll pass out. There's the Center for Agriculture and Food Systems and the Legal Food Hub, which is through CAFS. These are both really great resources for agricultural and food businesses. They can also provide through the Legal Food Hub pro bono attorney referrals. So similar to what we do for businesses, but specific to food and ag. Then this is, I'm not going to go through these individually, but you can see here, you can access the Vermont statutes for free online. The Vermont Secretary of State has a lot of information about business entities and how to register. You can get an employer identification number for free through the IRS. You can also get really useful tax information for businesses through the IRS website. The U.S. Patent and Trademark Office has a bunch of information as well, and also the databases that Professor Goodenough mentioned that can be searched to see if there's an existing trademark or patent. And then to register copyrights, there's a bunch of information on the U.S. Copyright Office webpage. And then I just wanted to mention at the bottom here, again, industry associations can be really, really useful resources. Common practices, sample contracts, attorneys who work with the industry, and then insurance agents. They give you a free quote, they can give you information about different policies, and they can help you understand what pitfalls to avoid. So those are the resources that we have. And we have 2 minutes for questions, but there's been questions throughout. Anybody have any other questions they want to pose? You can toss it into the Q&A.
And again, if that question that was earlier on the sole member LLC operating agreement, I'd be happy to talk about that a little further if there's any additional question on that.
Yeah. I just see a compliment from Laurel. Thank you, Laurel.
Well, if questions aren't appearing here, we do reiterate the fact that through the SBDC or directly with us on these programs, where there are opportunities for individual educational consultations. We can't give you advice because that would be practicing law, and that's not what these are aimed at. But we can give an educational background on a number of issues like the ones we've discussed today and beyond, and help people with referrals if that makes sense. So please do, if you have questions that kind of help would be useful on, don't hesitate to be in touch.
Mm-hmm. And I want to second the thank yous that are coming in through the chat. Thank you, Professor Killoran and Professor Goodenough. We really appreciate your contributions to the Vermont Small Business Development Center and to the Community Navigator Pilot Program, and your willingness to share your expertise with Vermont small businesses. I want to thank all the participants who are here today and those who are watching our replay. Please note that we will be emailing out the recording and the slides. And if you're watching the replay, check out the description for the video, because that will also link back to our website and the slides. We want to give a quick update that Professor Killoran will be joining us again on August 28th for another webinar about data privacy law and your business. We also want to encourage anybody who wants to reach out to the Vermont Small Business Development Center to please use that email that's on the screen. It is sbdc@vtsbdc.org. We also encourage you to go visit our website, which is vtsbdc.org. And then Professor Goodenough and Professor Killoran also included an email on how you can reach out to their program at Vermont Law and Graduate School. And we also encourage you to follow us on social media too. We'll be posting updates and new events as we move along the Community Navigator program. So thanks everyone for joining us today.
Thanks, everybody. right.